Ciadanella, our son and Realtas, Minister Jennifer Carroll McNeill.
Thank you, Ciarán. And I'd like to begin this morning by acknowledging the women who have had truly heartbreaking personal circumstances in pregnancy and whom I know have been the motivation behind this bill by the Social Democrats. Many deputies in all parties, in government and opposition, do know someone who has struggled in the worst news with pregnancy. And I think of all of those women who inspired the bill and your work on this debate today. I truly respect all deputies' commitment to raising these issues. I always vote to enable debate. I worked in government in 2017 and 2018 to support the repeal referendum, and I also want to thank the Social Democrats for meeting me on Friday, along with the state's interim Chief Medical Officer, Deputy Chief Medical Officer and officials from my department to discuss this bill. I'm grateful to them for that discussion. I think it was a very constructive discussion, and it gave me a much better opportunity to understand exactly what was trying to be put forward, because I did have some concerns and questions about the way in which it was drafted. I must say I'm always reluctant to criticise drafting of a bill, because I was a drafter in opposition for Fine Gael for 3 years, so I know how difficult that is, and I really respect that process. And I also agree that most legislation can be fixed if you agree on principles, that it can be fixed throughout the House, throughout the different stages. But in this case, I'm afraid I can't agree in that way, because the issues are based on principles, and I'll discuss those, that are so fundamental that they go beyond what I can agree here and fix later. A different approach, and I'm asking you to consider a different approach that potentially we could work with, asking you to consider that. I'm asking you to consider, could we, for example, facilitate an engagement with NWHIP and with the doctors who are discussing the improvements made since the O'Shea report, which you've correctly relied on in the drafting and the motivation of this bill, to consider how we could create a more structured engagement with any deputy who wishes to understand exactly what has changed and how that's working from their perspective. That offer remains open, irrespective of what happens today or any other time. So in that sense, this bill, the reality is that the words do matter, legislation does matter. We are here as legislators, and the courts presume that we mean the impact of the words that we say, and so the words really do matter. And this bill has raised significant both legal but operational concerns, and I have to bring those concerns to the House. The bill makes 5 major changes to the existing legislation, and in 4 cases I see policy difficulties as such, and 1 not, but in all they have legal difficulties. I don't believe in my heart that they were all necessarily intended, and that's why I'm so careful around this question of drafting, because I have done what you are doing, which is to bring something to debate, which is the purpose of this House in many ways, but it is also the purpose to enact legislation, and I have to point out the difficulties. So so there's 5 issues. First, and the least problematic in my view, the amendments on the 3-day waiting period. And the arguments for and against the removal of the 3-day waiting period have been well aired in the public domain. I personally don't see any difficulty with it. That is my personal position. It is a policy choice. The HSE advised that the current model of care is safe and effective, but that they're reliant on it. But that could change were the Oireachtas to make changes in legislation. So as I said, I think this is the least problematic. The only drafting issue, which of course this one could be fixed, is that you make reference to a statutory right to a reflection period, which doesn't exist. There is no reflection period that exists anywhere else. There is no such statutory right. But that is fixable. That is policy, and that is fixable. And I'll leave the rest of my comments to that, because I appreciate I've gone longer than that. But I would make the point that a woman is already entitled, as a matter of ordinary medical law and practice, to take any such time as she deems appropriate to consider her decision and to either avail or not avail. So I don't believe that creating a specific statutory right of reflection is helpful either. It's not a panacea to it. So it's just a drafting one, but as I said, that provision could be fixed. The others are more difficult. The second one is the reduction in the number of doctors making the decision, and you do that in 2 areas. So the bill proposes to amend the statutory language to remove the requirement for 2 clinicians to be involved in the decisions regarding the termination, a termination where the life or health of mother is at risk. Now, there are really practical and clinical reasons why the input of more than 1 clinician is relevant in the decision making. Doctors work as a team, and so where, for example, a woman's life or health is at risk because of psychiatric illness or cardiology issue or a neurology issue, of necessity you're going to need both the cardiologist and the obstetrician involved. That is just the practical medical reality. And removing or changing that creates an uncertainty that I don't believe is helpful, and courts will interpret that later, and that is meaningful. And I don't have time to go into exactly how meaningful it is, but again, then in section 11, change the number of doctors involved in the decision about a fatal fetal abnormality, not requiring them both to examine it. It's a subtle nuance and potentially to be dependent on notes. But again, the practical reality is that 2 doctors are necessary. You would have an obstetrician, but you would also have a geneticist, a neonatologist, the other doctor who is identifying the fatal fetal abnormality and the trajectory of that. And to be dependent then, changing the purpose of this, the threshold from examination to potentially including notes, it brings in a measure of uncertainty for the courts later. Well, hold on a second, you know what I mean? So are you saying that the notes going back to when? How does that, you know what I mean? There's an extra element of uncertainty, and I think you're trying to reduce uncertainty, not create it. And I wish I had more time to go through it. But the practical, the dual professional signatory is a fundamental principle of safety. It's widely practiced in healthcare, and it's a critical safety mechanism for high-risk actions and serious decisions. And this is a serious decision. And I am very aware of the tragic outcomes, unintended or tragic outcomes that have already occurred where core principles of safety have not been adhered to in that way. So it is, so in that sense, that is the difficulty with that. But it also legally, the bill provides that both of those sets of decisions would be based on reasonable opinion formed in good faith on knowledge available at the time. Now that is language that you did take from the O'Shea report, and I understand, and that is correct, and I understand the motivation behind that. But the legal, she's with every respect not a drafter, and when you bring in more words, so the good faith test is already well understood by the courts, and adding words to that introduces more complexity. The third issue is the ministerial clinical guidelines in section 9, 10 and 11. There is no, I don't believe, in short, that it's appropriate for me as minister or any minister to make clinical guidelines in any context. I think it's an interference in the independence of the medical profession, and I think that you may sort of be assuming that every minister is going to make guidelines that align to your view of the world. We already know that that is not the case in respect, for example, of the heartbeat law that was brought in Hungary in 2022, which, if a minister were to bring in something similar here in clinical guidelines, would require a woman to listen to the heartbeat before making a termination. I am a progressive right. If you're progressive left, I'm progressive right. But there are other members of this House that take a very different view, and I don't want any of them being Minister for Health and having the capacity to make ministerial guidelines, and I don't believe that we should bring that concept into legislation. I don't think it adds to what we're trying to do, to make things easy, to make things more complex. And if you're the doctor, you're introducing more uncertainty, because what you're doing is you're saying, here's the statutory rules, but then there's also these ministerial guidelines, and which does the court test? How does that work? And we are presumed to intend what the words, to intend an impact from the changes that we make in law, and the courts will view it as such. So I can't support that concept, A, because I don't want to create a precedent where we interfere in the medical profession in any area of clinical practice, whether it's obstetrics or whether it's cardiology. B, I don't want to give a different minister the opportunity to do something that would be very different to my worldview. I don't believe it's a concept we should embed in legislation. The fourth issue is the decriminalisation of medical practitioners. That's a very substantial policy and legal change. At the present, the doctor's decision doesn't have to be correct. They don't have to be right. They just have to have made it in good faith. That is the defence. But what a question arises as to why a doctor who carries out a termination unreasonably or acting not in good faith, in bad faith, why should they be exempt from criminal sanction? What is proposed is a blanket decriminalisation, and it's not confined to the woman's treating doctor, but to any doctor. So that is a very significant change, and that it's not just a drafting issue that could be fixed. I only have 1 minute, so I really want to deal with the most important issue, which is fatal fetal abnormality. It's extremely complex, and it raises so many different issues, ethical issues, and I can totally empathise with what the bill is trying to achieve. I myself have listened to, have met women who have faced unimaginable and harrowing circumstances. I want to explain why the 28 days is the way that the Oireachtas took that approach, because I know that that's not easy, desperately difficult for anybody who falls outside that. And it's only that I only have 1 minute to speak that I don't spend more time on that, so please forgive me, because I could detail some of those stories as you have. The death of a live-born, I don't mean to cause any upset for anybody now, but the reason it's 28 days is where there's going to be a condition that results in the death of an infant, it's nearly always certainly in the first 28 days. It's known as the neonatal period, that first 4 weeks. Of the approximately 190 infant deaths that occurred last year, about 150 of them were within that period. So it's not a figure that's chosen at random. It's chosen because it's related medically to the period where an infant is most at risk. Beyond that, it's extremely complicated. The people for profit, others have said the period should be up to a year. But if a baby can live for 2 months, 3 months, 4 months, I don't understand how you put a timeline on that or how you pick a timeline. I'd ask you to pick the number of days that are appropriate beyond 28 days, because I personally find it impossible. Instead, you have created the idea of a fatal condition that the fetus might have. And that is the most expansive position that anybody has ever taken, not just in this House so far, but it impacts any condition that an infant might have, that a child might have. It goes way beyond the neonatal period. A fatal condition in the fetus is also one that a child would have, and there are a whole range of conditions that we know as members of the Oireachtas, of people who are living till 7, 8, 9, 10, 20. These are fatal conditions, and there's no point shaking your head at me. This is the reality. This is true, and I really regret it, and I'm asking you to come with me, to take a different approach, take up my offer of meeting NWIP, take up my offer of debating this in a different chamber, because I don't want to be in a space against this when I know what you're trying to do is resolve the cases of so many women that have had such difficulty. But it is so complex. It is so complex, and I need more time and space to explain that.